Hello and welcome to the session on judicial politics in South Asia. And I'm very grateful to Neumann Rayat, who I'll introduce during the course of this session, for bringing all of us together and putting this very exciting and topical panel together. My name is Tarun Khaitan. I am the head of research at the Bonneville Human Rights Institute at Oxford, and also the professor of public law and legal theory at Oxford. Just a few housekeeping details out of the way before we will dive into the panelists directly. So each panelist will present for between 10 to 12 minutes. As participants, please note that the event is being recorded, and that's not just the panel speakers' opening remarks, but also the Q&A. So if you don't want your question to be recorded, it's probably best not to post your question. I think there is a facility to post questions anonymously, though. So if you don't want your name to be used, you might be able to raise a question anonymously. And in order to ask a question, please post it in the Q&A box. You will see a Q&A box at the bottom of your screen. If you click that, that will give you the opportunity to post a question that will be visible to the entire panel. Please do not use the chat function. And please don't use the raise hand feature either, because we will only take written questions, not oral questions. Once a question is posted, participants should also have the option of upvoting a question that somebody has already asked. So if your question is similar to or the same as a question that somebody else has already posted in the Q&A box, instead of asking the same question again, just upvote the question. So basically, it's a system of prioritizing which questions, as chair, I should take up first. And obviously, I will exercise some discretion as chair, but a question with more upvotes will be taken up, more likely to be taken up before other questions. And and finally, I think that's all the details I have to give to you about the event. We will aim to finish on time, which is within 1.5 hours. You don't have to wait for all of us to finish speaking before posting your questions. You can start doing that at any point during the panel. The details of all the speakers, their bios, as well as the abstract of their talks is available on the Eventbrite page where you registered for this. So if you missed something, you're welcome to look at that. I will give quite brief biographical introductions to our panel members just before they start speaking. But the overall panel we have today includes speakers from a range of South Asian jurisdictions, not all of them. Sadly, we don't have representation from, say, Nepal or Maldives or Myanmar or Bhutan, but we do have Professor Ridwanul Haque from the University at North Institute, Charles Darwin University, Australia, and also the Department of Law at the University of Dhaka. And he's an expert on judicial activism and inclusive constitutionalism. And we will start with him as the first panel member. I will introduce the other speakers just before they are due to speak. So, Professor Haque, can you please start your presentation? Thank you.
Thank you, Professor Tarun Khaitan, and good day to everyone. Well, this is a fantastic topic and fantastic panel to discuss the judicial politics in South Asia. And my role here would be to reflect on Bangladesh experiences, and the topic that I have chosen is judicialization of politics and politicization of the judiciary. I haven't made any presentation in terms of PowerPoint presentation, but I have a very small descriptive paper of 2.5 pages, and sometimes I'll be reading from here, and sometimes I'll be just speaking without the help of this paper. Uh, we are living in an age of judicialization of politics. This phenomenon is probably a byproduct of, or arguably a predecessor to the concept of politicization of the judiciary. In South Asia generally, we have seen the impact of both phenomena. The bitter memory of miscarriages of chief justices in Bangladesh, Pakistan, and Sri Lanka is quite recent. And in the same way, the Bangladeshi, Pakistani, and now the Nepalese Supreme Courts have entered into the field of excessive judicialization of politics in terms of, for example, in case of Bangladesh, by invalidating a caretaker government system that remains during the election time. I'll discuss this a little bit in more detail later. And in cases of Pakistan and Nepal, by unseating the incumbent prime ministers. Now I'd like to begin straightforwardly with the Bangladesh experience. In the context of continuing political instability in Bangladesh, and now a sharp decline in democratic practices, politicization of the judiciary and judicialization of politics have gone hand in hand, mostly based on abuses of two adjudicative technologies, very known or famous, public interest litigation and the doctrine of basic structure. The Supreme Court of Bangladesh has handed down decisions that are unpragmatic judicial intervention into politics. And it has not only been unprincipled policy making, but has also intervened into mega politics. An inevitable consequence of judicial intervention into politics needs to be made known here, and this is repercussions from the executive government or other myriad forms of consequences, political. Based on a critical assessment of consequences of unpragmatic judicial intervention into politics, I propose to argue that indeed it's possible to develop a theoretical framework for the purposes of judicial engagement with political issues, with constitutional issues entwined with politics. I'll argue that with effective strategies and judicial craftsmanship combined with constitutional wisdom, a constitutional code can help stabilize constitutionalism. Now, which is first? It's about judicialization or politicization. Is the question like, which is first, the egg or the chicken, something like this? And for the purposes of politicization, is it simply appointing judges in the party lines, or it is something else? As far as Bangladesh is concerned, I think it's a total package of activities on the part of the executive branch. Some are overt and some are covert. In every jurisdiction, there are political considerations when appointing judges to the top court or the Supreme Court. In Bangladesh, it is something more. Current Law Commission chairman, for example, was the former Chief Justice who was involved in the decision called 13th Amendment case. I'll reflect more on that in a while. On the other hand, one former judge of the Supreme Court, for example, received some grant from the Prime Minister's treatment fund for not that apparent illness. And he used the fund to go to London and get treated over there. This adds this tendency or this practice adds fuel to both political and judicial populism. Judges in Bangladesh are drawing attention while while writing their decisions or judgments or opinions. Attention of the Prime Minister quite often. In a recent case involving the legal personality of decision of rivers, this happened in quite a noticeable fashion. Now I'd like to discuss two cases very briefly to bring into the fore the crux of the problem of judicialization of politics and politicization of judiciary. The two cases are cases about the constitutionality of constitutional amendments. The first one is the 13th Amendment case. By 13th Amendment, the Constitution inserted into it a system of the government for 3 months that would oversee elections during election time. And in a case, Abdul Mannan Khan case in 2011, reported in 2011, the Supreme Court's appellate division held by a 4-3 majority margin that caretaker government system is unconstitutional. But the caretaker government system was introduced based on political consensus. And it came through a short order made in May, on 10th of May 2011. Then that was done just 8 days before the Chief Justice, who I've said that who later accepted the position of chairperson of the Law Commission. And this case was heard in an expedited way, but the case as an appeal remained in the dock of the appellate division since 2005. On the other hand, before this case was decided by a short order of 3 sentences or 3 lines, there was a parliamentary committee that was looking after the reform of the constitutions, and they favored in favor. I mean, they gave their opinion that the caretaker government should be retained. However, following the short order of the annulment of the caretaker government decision of the amendment, Parliament rushed and made the 15th Amendment to do away with caretaker government system. Since then, the Bangladesh has entered into a hybrid type of regime and continuing political democratic backsliding. So as a result, 2014 elections was unilateral or one-party elections, and 2018 elections was participatory, all in name, but not in any real sense of the term. Then I'd like to reflect on another case, that 16th Amendment case. The 16th Amendment case is about the judicial removal process. In the original Constitution, there was a provision that said that a judge of the Supreme Court would be removable by Parliament 2/3 majority. And pursuant to that, the President would sack or remove the judge. So that was the original provision. But in 1975, that was withdrawn. And in 1977, a Pakistani-style system was introduced, which is the system of Supreme Judicial Council of 3 judges to remove the judges of the Supreme Court. Now, and this change was internalized in the Constitution in 1979. At one stage, by 5th Amendment, at one stage, the Supreme Court annulled the 5th Amendment as unconstitutional, but retained the Supreme Judicial Council, which is something like, I mean, taking the fruits of a poisonous tree. However, by 16th Amendment, the Parliament restored the original provision of the judicial removal, and then it was challenged before the Supreme Court. The appellate division, in a unanimous judgment, this time it's not split decision, not 4 versus 3. In a unanimous decision, held that this restoration of original judicial removal scheme is unconstitutional. So now I would like to, shed light on the nature of this decision, and I draw my conclusion very quickly. In a recent article published in ICON, International Journal of Constitutional Law, 2021, constitutional scholars Faujan Yep and Rehan Aberat argued that this 16th Amendment decision is both defensible theoretically and on pragmatic grounds. My argument is that this decision is theoretically indefensible. It cannot be defended theoretically, and it's extremely unpragmatic. The predominant reasoning for my position is that the court lacks a power, the court doesn't have a power to invalidate an original provision of the Constitution. To conclude, the theories of constitutional supremacy and popular sovereignty require the judges to apply the doctrine of unconstitutional constitutional amendment extremely cautiously and rarely, and only for the cause of preserving the identity of the nation or the Constitution. As for the theoretical framework of judicial legislation politics that I talked about at the beginning, the court should not get involved in the adjudication of mega political issues, such as the structural issues like the validity of a government, the 13th Amendment case, or an original constitutional provision like the 16th Amendment case. In these two cases, the challenges were through PIL, public interest litigation. So the court did not incur even the basis of local standing in regard to such important issues of constitutional significance. Consequences were dire that we have seen, leading the country into a situation of constitution without constitutionality. With that note, I would like to stop here. Thank you very much.
Excellent. Thank you very much, Professor Hogg. You kept very much to time, 4 seconds to go. So that's very helpful. And also for framing the conversation today, because I believe all of us are going to think about the role of the judiciary in the context of fragile, unstable, or threatened democratic context in South Asia. Before I invite our next speaker, I just wanted to share a quick link to the latest editorial issue of the Icon Journal, where Adem Adebe has talked about constitutions trying to undo the advantage that incumbents have. In Bangladesh's 13th Amendment discussion in the case law is one of the prominent examples discussed there. So it might be useful to see that in a more comparative perspective. It's in the second half of the link that I've just shared with everybody. But with that, thank you very much, Professor Hogg. And I will now invite our second speaker, who is Dr. Dinesha Samararatne. She is a senior lecturer at the Department of Public and International Law at the University of Colombo and has just returned to Sri Lanka after a stellar stint as a postdoctoral fellow at the University of Melbourne. So over to Dr. Samararatne.
Thank you, Tarun. I must thank Nauman and also the organizers of this event for inviting me to contribute to this discussion on judicial politics in South Asia. It's always a pleasure to be involved in a regional conversation, because each time I have done so, I have come away with not only with insights to what's happening in the region, but I'm also able to understand the Sri Lankan context slightly better. So thank you for this opportunity. I must also flag that I'm still recovering from what seems to be a extended flu. So if I have to stop when I'm speaking, I ask you to please bear with that. So with that, let me begin. So I want to talk about what I think is judicial innovation in Sri Lanka. I think it's fair to say that both academics and activists alike who study Sri Lanka's judiciary generally agree that at least since Sri Lanka's independence, judicial independence has been weakened due to challenges from without, but also from within. So I'm not going to repeat that well-documented analysis today. What I hope to suggest today is that despite these issues with judicial independence, a close reading of judicial developments reveal examples of judicial innovation, Now, if my reading is accurate, I think it complicates the hitherto well-accepted narrative about the Sri Lankan judiciary. Now, I hope to do this in the following way. First, I will briefly refer to the general history of the Sri Lankan judiciary, just to give you some context. Second, I will highlight some of the current issues related to judicial independence in the present moment. And using that as a background, I will present to you what I consider to be 4 examples of judicial innovation. Now, on the history, very briefly. Sri Lanka's judiciary was established as an independent and separate branch since 1801. Previous academic work has established that during colonial rule, the judiciary functioned independently. The In re Brace Girdle case, where a writ of habeas corpus was issued to secure the release of a political activist in 1937, is considered to be an emblematic case in this regard. The post-independence trajectory, the overall trajectory of the judiciary, is presented as one of gradual decline, particularly due to external threats, including constitutional design and constitutional reform. The purported impeachment of our 43rd Chief Justice in 2013 and the problematic way in which he was restored to office in 2015 is a more recent example of some of the more serious types of threats faced by Sri Lanka's judiciary. Now to the more contemporary challenges, and I will only highlight 4 of them. The 20th Amendment enacted in October 2020, replaced the Constitutional Council, which had the authority to approve appointments by the President to the higher judiciary as well as to the Judicial Service Commission. Now, this was replaced with the Parliamentary Council, which has no binding powers. Additionally, the 20th Amendment expanded the Court of Appeal from 12 to 20 and the Supreme Court from 11 to 17. A second challenge would be that stemming from a Presidential Commission of Inquiry that was appointed in January 2020 to inquire into political victimization. Now, this report was tabled in December 20. The report was presented to the President in December 2020. The report has not been published. But the Prime Minister in April 2021 tabled a resolution in Parliament seeking to give effect to some of the recommendations made by this commission. Now, according to that resolution, some of the recommendations include filing charges against prosecutors and investigators who had initiated prosecution on charges of corruption, financial irregularities, and other criminal offenses. It also includes the recommendation to discontinue certain trials. Now, a second Presidential Commission of Inquiry has since then been appointed to review recommendations of previous commissions, and this commission's proceedings are not open to the public. In fact, we had a interim order issued by the Court of Appeal yesterday staying the proceedings pursuant to one of the recommendations of this commission. The third contemporary challenge, a former member of parliament convicted of murder and previously a former army officer convicted of killing 8 Tamil civilians, including 3 children, were pardoned by the president. Whether the constitutionally stipulated procedure was followed in granting these pardons, including the consideration of a report by the judge concerned, remains unknown. And finally, a sitting member of parliament was convicted and sentenced for 3 years with rigorous imprisonment for contempt of court. Sri Lanka's contempt of court is found in the common law, and attempts to codify the law has so far not been successful. Now, these contemporary issues unfold in the backdrop of other enduring problems such as laws delays. The Parliamentary Select Committee found in 2017 that on average it takes 17 years for a criminal case to be concluded before courts in Sri Lanka. Now, despite the negative picture that I have painted so far, I am now going to suggest that there is evidence of judicial innovation, revealing the need to qualify some of the thinking on the Sri Lankan judiciary that we have at the moment. In the interest of time, I will only provide you a quick overview. So the first is the constitutional entrenchment of the executive presidency. The text of the Constitution does not entrench the executive presidency. However, over time, the judiciary has consistently ruled that any restriction of the powers of the president requires approval at a referendum. Where governments have occasionally sought to expand the powers of this office, court has not required approval at a referendum. The only exception to this is the Supreme Court striking down the reintroduction of presidential immunity during office under the proposed 20th Amendment. The second is judicial review of legislation, or the limited judicial review of legislation. The Constitution explicitly prohibits judicial review of legislation. However, in relation to two aspects, one of administrative law and the other of criminal law, respectively, the judiciary has engaged in judicial review of legislation. In administrative law, this has been in relation to striking down legislative ouster clauses, and in criminal law, the court has declared that legislative imposed mandatory minimum sentences for the offense of statutory rape is a violation of the right to equality and the right to be free from torture. The third innovation that I want to suggest to you is the direct judicial incorporation of international law, particularly in relation to environmental law. Now, this is despite in 2006, the Supreme Court itself declaring that Sri Lanka is a dualist state, etc. I won't go into that in too much detail. And finally, the fourth judicial innovation, which for me is personally of interest in the present moment, is the gradual transformation of the common law in Sri Lanka. Now, it is established, or at least textbooks tell us, that our common law is the Roman Dutch law due to our colonization history, and that the English law has been a source of law in public law and in commercial law. But I think the time has now come for us to re-evaluate this received wisdom. There is evidence to suggest that Indian law is increasingly performing the function of common law, not just in public law, but perhaps also in other areas of law. Of course, finally, the so what question. So for me, each of the examples of judicial innovation that I presented suggest insight or offer insights to judicial character, quality, and politics over time. These examples, I think, provide a rich evidence base with which one can develop an alternative perspective for evaluating the role of the judiciary at a time when judicial politics is being framed in a particular way. I think I will conclude there for now, and I'm happy to take any comments or questions during the discussion. Thank you.
Thanks very much, Tanisha, for excellent timekeeping and for that very interesting and nuanced presentation. I want to share with the readers a link to Tanisha's excellent commentary on the 20th Amendment in Sri Lanka. And I guess I read Tanisha's presentation as drawing attention to not just the high constitutional cases that we often focus on to think about judicial politics, but take a more holistic view of what the court is doing, even in cases that we may not see as particularly landmark, so to speak. So thanks very much, Nation. Our next speaker is our organizer of the panel today, Mr. Norman Rayat, who I've already thanked for bringing the panel together. He's recently completed his PhD on judicial independence in authoritarian and hybrid regimes from the Department of Politics at the University of York. And we look forward to your presentation. Over to you.
Thank you, Tarun. Before talking about my topic, just allow me to say thanks to all those registered their interest in this event and all those who expressed their desire to collaborate. I'm very thankful to you. Today I will be talking about judicial populism and judicial independence in Pakistan. And the main argument of today's presentation is that judicial populism contributes to distinct aspects of judicial independence in authoritarian and hybrid regimes like those in Pakistan. Between 2005 and 2021, the emergence of a judge as a national leader, anti-regime and pro-judiciary protests, increasing public interest litigation, the media's extraordinary focus on the Supreme Court of Pakistan and popular decision of the Supreme Court of Pakistan indicated judicial populism in Pakistan between 2005 and 2021. And this encouraged the court to demonstrate a certain degree of independence. However, the question arises, how do I see judicial populism? The first, the existing literature has already talked about, the main ingredients of the concept of populism. People is public support. People is the main core concept, ingredient of the concept of populism. Anti-elite behavior is another. Some literature have also reported media's focus, media's involvement in the different movements led by different leaders and people, different groups, social groups. That also indicate populism. And the leader, the different group, if led by a leader, that is the involvement of a presence of a leader is one of the indicators of the concept of populism. But these are the ingredients of populism. How do I see judicial populism? So the first thing which I would like to say is, what is popular and what is not popular? It varies from one context to another. Issues like gay rights and LGBT and other things may be popular in one jurisdiction, but it might not be popular in jurisdictions like Iran and Pakistan and other countries where there's a lot of religious influence. So having this said, what I do, I borrow different indicators from the literature on populism and see if the judicial behavior is in line with those indicators or not. And then I constructed this concept. Instead of going for straight away popular decision making by the judges, I borrowed public support for judges anti-elite behavior, media's focus on the judges as leader in Pakistan. So focusing on these indicators, I measure judicial populism in Pakistan. But another question which arises is, who are people and whose support we are talking about? Am I talking about 220 million population of Pakistan who express their support for the judges? No, I'm not talking about 220. It's not possible. Laborers and farmers who they have very minimum awareness about the judicial issues and the legal debates. So I'm talking about support of heterogeneous groups. So heterogeneous groups of people, the society, such as lawyers, civil society organizations, political elites, and even students whose support was visible in the lawyers' movement for the restoration of the judiciary from 2007 to 2009, and later on in the public interest litigations under Article 184(3) of the Constitution of Pakistan, which empowers the Supreme Court of Pakistan to make any decision with regard to the enforcement of fundamental rights and public interest issues. Then when I say judges anti-elite behavior, what do I mean by elites? Which elites I'm talking about? I'm talking about the military elites, political elites, and political elites, military elites, and the social elites. So if we see from 2005 onwards, the annual report of the Supreme Court of Pakistan and the decisions, that suggest that the judicial behavior was against mainly political elites and then in some cases military elites. Then coming to the third indicator, media's focus on the judges, the different works and the recently published articles suggest that there were newspapers and the TV channels had an extraordinary focus on the Supreme Court judges. So much so that, during my field work, I found that many court reporters were given specific places within the courtrooms, and some of the judges even, they had to wait for court reporters so that the remarks can be covered and then it can be reported by the media channels. And also, if you see during the lawyers' movement for the restoration of the judiciary, many media channels such as Geo News channel, they ran marathon transmissions, and not only marathon transmission, but also the campaigning for the restoration of the judiciary. So media's focus was, there was an extraordinary focus of media on the Supreme Court judges, especially from 2009 onwards. Not a single newspaper, the headline were mostly about the Supreme Court of Pakistan. However, as the main argument is judicial populism contributes to judicial independence. So the question is, how do I see judicial independence? Now, I see judicial independence in terms of 4 indicators: the increase in decisions of the Supreme Court of Pakistan against the executive, parliament, and military from 2005 onwards, the implementation of those decisions that indicate the de facto, these 2 indicators indicate de facto judicial independence, court's protection against court packing measures, the restoration of the Chief Justice back in 2007. He had been suspended for certain degree of independent behavior by the then military dictator General Pervez Musharraf, and later on had been restored as a result of the lawyers' movement for the restoration of the judiciary, and other judges who were removed in November 2007. So all of them were restored in March 2009. So court protection against the court packing measures, which were not visible before 2005, many military elites, they intervened, they took over the government, removed the judges, but the court was not able to protect itself. However, after 2007 and in 2009, they were able to protect themselves. So that showed a certain degree of increase in the judicial independence. Court's protection against court curbing measures. Court curbing measures means to limit the power of the court. For example, the Contempt of Court Act 2012 that tried to limit, enacted by the then hybrid regime of Pakistan People's Party. They tried to limit the powers of this, contempt of court power of the Supreme Court of Pakistan. So that was, the court was able to protect itself by striking down that act. Now, here is the usual question which I received is why don't I look at impartiality? So I didn't look at impartiality because impartiality itself is a very is almost immeasurable, because in every legal decisions are basically legal decisions. They are full of the legal doctrines. Judges make references to the constitutional provisions, the precedents. You interview a judge, they are not going to say that, I made a decision because of the, political context. I made decision in accordance with the law. You ask, during my field interviews, I asked military generals, judges, CSOs, civil society organizations, representatives, what is judicial independence? That was the first question. And the answer I used to get was, the judge's behavior, judge's decision in accordance with the law means judicial independence. But every jurisdiction in every court, the judges there, they make decision in accordance with the law. They don't make decision otherwise. So it's very difficult to say that judges are impartial. And there's another critique. The usual criticism which I receive is, and mostly from the people scholars in the authoritarian and hybrid states. They say they usually look at the American states and the American Supreme Court and the UK Supreme Court, and by saying that the judges here are very impartial. Well, my question is, if judges are here, my answer is, if judges are here are impartial, then what's the debate about judicial diversity, and why some judges say that the Johnson's prorogation, we can look into that and we can review it, and other judges say this is not for the judiciary. Which judge will be, who you can see as impartial or you can see independent? So that's why I didn't look at the impartiality. I focused on these 3-4 concepts: decisions against the military elites and the executive and the parliament, implementation, court protection, and against court curbing and court packing measures. Now, did it contribute? How did it contribute to the independence? It contributed. The judicial populism contributed to judicial independence in Pakistan. It was visible in the popular demonstrations for the restoration of the judiciary from 2007 to 2009. So if you see the involvement of different heterogeneous groups of society was very much visible in different cities. The Chief Justice himself paid countrywide visits, and different people attended the gatherings. And as a result of that movement, that events, the judges were ultimately restored. When judges were ultimately restored because of the people involvement, they felt encouraged to make decisions against the elites. It was only after 2009 that they started behaving independently. And this sequence of events showed that the populism contributes to the independent behavior, because it didn't happen before 2009. The pattern of decisions, the increases, the significant increase in decisions against the political interest of political elites and the military elites before 2009. It happened after 2009. So that sequence of events showed that the judicial populism contribute to judicial independence in Pakistan. The rest of the question I can answer in the Q&A session. Thank you very much.
Thank you very much, for helping us think about judicial populism and independence from the lens of who they are willing to take on, rather than just focusing on it doctrinally. Just as a comparative insight, many people in the audience might already know of Anuj Bhavania's book on the populist turn of the Indian Supreme Court, but I've posted a link in case you haven't seen it. And he basically sees that move as having damaged Indian judiciary in a significant way, when the judges also start competing for popular legitimacy. So then we move to our penultimate speaker, after whom I will speak. So this is Mr. Muhammad Qasim Danishar, who is a justice and judicial affairs expert at the Administrative Office of the President of Afghanistan. And previously, he has served at the Administrative Office of the President of Afghanistan as the rule of law and anti-corruption expert, and the Attorney General's Office of Afghanistan as a prosecutor. And he's also been a lecturer and later dean at the law faculty of the University of Saeed Jamuluddin Afghan. We're really pleased to have you, Mr. Danishar, especially given the particularly tense political situation in Afghanistan. So thank you very much for finding time for us, and we look forward to hearing from you. Over to you now.
First of all, thank you very much, and I would like to appreciate Dr. Dirman for his invitation. As a matter of fact, I'd like to talk about judicial independence in Afghanistan, but because of limitation of time, I think we have 10 minutes or maybe 12 minutes, and it's not possible to discuss all the issues about the independent judicial independence. But I would like to history and historical background of Afghanistan constitution. But I can say that the democracy has brought a new modern constitution for Afghanistan. This new modern constitution of Afghanistan has recognized all the basic and fundamental human rights, social and cultural values, and so on. Also, separation of powers, among which we can find judicial independence. It is quite clear that the judicial power is a political institution. Not only it is politically constructed based on Article 116 of Afghanistan Constitution, but also because it is given constitutional legal authorities, judicial behavior, and independence. Furthermore, some international legal instruments such as International Declaration of Human Rights, International Covenant on Civil and Political Rights, the basic principles on the independence of judiciary, the Bangalore Principle of Judicial Conduct, and likewise ensures the judicial independence and impartiality. For instance, Article 10 of the International Declaration of Human Rights and Clause 1, Article 14 of the International Covenant on Civil and Political Rights emphasizes on impartiality and judicial independence.
Mohammed, I'm sorry to
in
interrupt
relation
you.
to this,
Mohammed, I'm very sorry to interrupt you. I think we're having some difficulties hearing you because of your connection. So Craig is going to turn your video off, but we can still hear you, and hopefully we'll hear you better. So I hope that's okay. And please continue. Thanks very much.
All right, great. So the reason why I addressed the international legal instruments and Afghan constitution is to concentrate on the coherent relationship and to find how they have recognized judicial independence and impartiality. Therefore, Article 116 of Afghanistan constitution ensures the judiciary independence. This article cites that the judiciary shall be an independent organ of the state of the Islamic Republic of Afghanistan. The judiciary shall be comprised of one Supreme Court, courts of appeal, as well as primary courts, whose organization and authority shall be regulated by law. The Supreme Court shall be the highest judicial organ having the judicial power of the Islamic Republic of Afghanistan. As well as Article 123 of the Constitution has stated that with respect to the provisions of this Constitution, statutes related to the formation authority, as well as proceedings of the courts and matters related to judges shall be regulated by law. Based on these two articles of the Constitution, which I addressed, law on organization and jurisdiction of the judiciary of Islamic Republic of Afghanistan is made, which is in force at the moment. Anyway, in order to do not talk more generally, and let's be clear, let's clear the term independence. The term independence is not explicitly defined in Afghanistan legal system, but what do we know about is that judicial independence is the ability of courts and judges to perform their duties free of influence, controlled by other actors, whether governmental bodies, parliament, and private sectors. As I mentioned before, the Constitution of 2004 addressed key aspects of independence of judiciary. The Constitution has provided a chapter under the name of the judiciary, which has 20 articles. This chapter covers topics such as the structure of judicial power, how the members of the Supreme Court appoint and condition of their election, affairs related to the administration, to the administrative staff, and authorities of the judicial, budget of the judiciary, and its implementation by the judiciary itself. Appointment, transfer, promotion, punishment, and proposal for retirement of judges. Moreover, some ordinary laws made under the regulations of the Constitution for judiciary power also covers some issues like security of tenure, suitable salaries for judges, and restriction of judges in selected activities. It also ensures participation of the Supreme Court in preparation of legislation in judicial affairs and preparation and implementation of judiciary budget. Moreover, the law on organization and jurisdiction of the judiciary has added extra measures with objective to enhance independence of the courts and the judges. Among other topics, this law regulates admission to judicial cadres, appointment procedures, and transfer of judges, on-the-job training, and principles of impartiality. Additionally, all procedural laws, namely civil procedure law, criminal procedure law, and commercial procedure laws, have a special measures to ensure impartiality of the judges. In order to give you an overall picture of the judicial independence in Afghanistan, I would like to discuss on three aspects of the judicial independence, which is institutional independence of the judiciary, individual independence of the judges, and independence of the judges from influences exerted from inside the judiciary. The issues which we are going to discuss in institutional independence of the judiciary, the first one is the budget. The Constitution gives power to the judiciary to prepare its budget. It must be submitted to the executive branch to be finalized and as part of the national budget submitted to the parliament. The second issue is non-interference by the executive branch. The Constitution of 2004 establishes a strong executive branch by assigning tremendous power to the president, which includes power related to the judicial branch, such as appointed justice of the Supreme Court, as well as justices of the Supreme Court with the endorsement of the House of People, appointing, retirement, and accepting the resignation and dismissal of judges according to the provision of law, reduce and pardon penalties in accordance with the provision of the law. All final decisions of the court should be enforced except for capital punishment, which should require presidential approval. Therefore, there are two different opinions on the role of the president as the head of the state. The first opinion considers the president as a highest authority of the state that exercises power in all three branches. Therefore, the legislative and judicial branch should report to him. Under the second opinion, it is argued that the Constitution of 2014 is based on clear lines between branches of the state. Each branch has a special role and none of the branches is subordinate to the other. Based on this opinion, the State of the Islamic Republic of Afghanistan, as mentioned in Article 60 of the Constitution, is a special name used for the country of Afghanistan. While the president is considered the head of the state, this designation does not mean the other two branches should report to the president or be subordinated to him. As I said before, so because of not having much time, so I would like to be brief, I said. In fact, in the institutional independence of the judiciary, we have some elements that is like non-interference by the legislative branch, administrative affairs of the judiciary. In the administrative affairs of the judiciary, we have some other issues like financial independence, which the Supreme Court has this independence, involvement in preparation of judiciary relation legislations, and as well as enforcing decisions of the courts. What we see in the independence of the Supreme Court is the individual independence of the judges, like decision-making, appointment, removal, and tenure, impartiality of judges in decision-making, financial remuneration, security of judges, restricted activities. And the third element that shows the independence and impartiality of the judiciary power is independence of judges from influence exerted from inside the judiciary. And this element consists of three other factors like independence of each court and each judge, performance assessment and the promotion of judges, and the transfer of the judges. So in conclusion, I can say that according to the legal system in Afghanistan, we do have judicial independence and judicial impartiality. And this was just brief, and I would like to thank once again the participants and particularly Dr. Nerman for the invitation to this conference. And thank you very much.
Thank you very much, Mahmoud, for keeping to time and for that really interesting background to the Afghan constitution. I'm posting a link to a really interesting and useful handbook to the Afghan constitution that a student group at Stanford wrote and published, and a review of this book that was recently published by the Indian Law Review. So I'm going to start my presentation now and hopefully try to keep time. But before I do that, I just want to remind the participants once again, I can see that you've started posting questions on the Q&A box, but please continue to do that, and please use the upvote mechanism to signal to me which questions are of wide and broader importance for this audience. So with that, I will start my presentation. And I'm going to talk about the idea. Well, I'll focus on judicial interpretation. And unlike the four other panelists, I'm going to focus less on contemporary judicial politics, but judicial politics in India's founding moment. But obviously one that has very serious implications even today, and I suspect not just to India. And then before I open the floor, I will try to draw connections between the papers in my duty as a chair, but that will be after my presentation. So I want to speak about a concept that I believe should be a lot more well known and talked about in constitutional theory, but isn't, and that is the idea of aversive constitutionalism, which was introduced by Professor Kim Lane Shepley in an article she wrote in 2003. And there she distinguished between, I'm posting a link to the article in the chat box for anybody who might be interested. For some reason, the chat box is not letting me post it, but I will do it later. So she talked about the distinction between constitutions and approaches to constitutional interpretation that are either aversive or aspirational. Now, just a second layer to this, I want to superimpose this on a different distinction that was highlighted. It's been highlighted by many people. Carl Clay talked about transformative constitutionalism in the context of South Africa. But Gary Jacobson has also discussed the idea of militant and acquiescent constitutions. So some constitutions that are acquiescent constitutions, they don't seek to change their societies. They just want to fit into their societies. And that's contrasted with either acquiescent or militant constitutions that seek to, by transformative or militant constitutions that seek to change the societies. And to varying degrees, we can think about which South African constitution is acquiescent or transformative. And also that these identities are not fixed in history, that constitutions can, acquiescent constitutions through judicial interpretation or constitutional practice can become transformative and the other way around, right? So I see Kim's distinction between aversive and aspirational constitutions as a distinction between two different types of transformative constitutions. Constitutions that want to change their society. But the key distinction is that aversive constitutions or aversive constitutionalism seeks to change its society to make sure that a historical trauma, a terrible past event or a terrible past era of that polity never happens again. Right? So it's aversive. It's telling the polity, it's a moment where the polity decides never again. The South African Constitution is a very good example of aversive constitutionalism. So while being transformative, its key commitment is being an anti-apartheid constitution. It's a constitution that says never again will we get to that kind of history that we went through with apartheid. And this is announced in the very preamble of the Constitution of South Africa. We, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, adopt this constitution as the supreme law of the republic to heal the divisions of the past. Right. So it's a very much a backward-looking constitution, and that's not meant as a criticism, by the way. A backward-looking constitution looks at the past and says never again. That's to be contrasted with what Kim calls aspirational constitutions. Constitutions that are entirely forward-looking, that have a political utopia of sorts, and they tasked their constitutions to seek that utopia. And my view is that at least in the text of the Indian preamble, the Indian Constitution is a very good example of an aspirational constitution. Right? There is no mention, at least no explicit mention, of the past, of the colonial regime, of the constitution as a mechanism to overcome not just colonial rule, but colonial ideology. It's entirely aspirational, an aspiration in securing justice and liberty and equality for its people. Right? So, having set up that frame, by the way, what I'm presenting is a paper that I've just begun writing, so if any comments or thoughts would be very welcome. There is an early moment. So the Indian Constitution, at least textually, is already set up to be an aspirational rather than an aversive constitution. However, in the first decade of constitutional adjudication, there is a possibility that through judicial interpretation, this constitution could have become an aversive constitution, or at least have a strong aversive dimension alongside its aspirational dimension. There's a possibility in the judgments of one particular Supreme Court judge, who is Justice Bose, which some of you may have heard of, who in a lot of his judgments revisits this question of what kind of nation, what kind of state, what kind of country do we want to build, and what have we learned from our colonial history. Right? And I'm just going to mention his dissenting opinion in one key case, in the Anwar Ali Sarkar case, to give an example of the possibility of a judicial politics that could have embraced aversive constitutionalism and what that might have meant for constitutional interpretation in India. So Anwar Ali Sarkar is a case where in an independent Indian state, this is decided in the early 50s. So it's a very early case, and just at the cusp of independence, right after independence, under the new constitution. But an Indian state passes a special courts act to deal with political offenses, right? Offenses, and it is engaging with prisoners, with convicts who are being tried for political offenses under a mechanism that is fast-tracked, that does not abide by all the requirements of rule of law, that even under the colonial criminal code standard, right? And obviously that rings very strong bells with the Rowlatt Act and the colonial regimes to deal with political prisoners without going through rule of law. And, there's also preventive detention issues, etc. So the majority tolerates largely this new regime. But this is what Justice Bose says in the case. I'm just quoting a little bit extensively. So I find it impossible to read these portions of the Constitution, which is the fundamental rights chapter, without regard to the background out of which they arose. I cannot blot out their history and omit from consideration the brooding spirit of the times. And then he says the Constitution says they arose, just in the context of Article 14 of the Indian Constitution, the right to equality, it arose out of the fight for freedom in this land. It is an endeavor to compress into a few pregnant phrases some of the main attributes of a sovereign democratic republic, as seen through Indian eyes. And basically, within this historical contextualization, he locates what was freedom worth if this is precisely not what we fought against. Right? So that is broadly the inauguration of aversive constitutionalism in India, which is stillborn because the other judges don't pick it up, and this is rolled back relatively quickly. So to conclude, because my time is running out, I just want to say that a stronger commitment to aversive constitutionalism would have challenged many of the colonial continuities that we see in India and in South Asia at large, where we have a huge problem with judicial respect for civil liberties and a huge tolerance for huge judicial tolerance of state authoritarianism, despite honorable exceptions. I think a strong commitment to a never again attitude to might have led to a different outcome. But I'll stop there, and I will invite our attendees to continue to post their questions, which I'll start taking in a moment. But before I do that, I just want to take a minute or two to tie together some of the themes that have emerged from the presentations by different panelists. And as I see it, most of the panelists have touched upon different aspects of judicial politics from particular vantage points, from particular lenses of their own jurisdictions, but obviously things that apply to almost all, if not all, of the jurisdictions we have discussed today. And one is quite clearly appointments and independence of the judiciary, the Constitutional Council approach that Dinesha talked about, where it's the president as well as the opposition that has a say in judicial appointment and an equal say, and the fight in Sri Lanka over that, which is pioneered by Nepal and the Bangladeshi worries and Pakistani worries about appointments. And that ties into Mohammed's presentation on Afghanistan as well. That's one prong of judicial politics. The second prong is the ability or the desire of the courts to take on elites that can threaten democracy and its effectiveness in doing that. And that came out quite strongly in Norman's presentation, but also in Ridwanul's presentation, where it seems that sometimes politicians can be better at protecting democracy. And it seems that Ridwanul seemed to suggest that the caretaker government during elections idea was a good one that had broad political consensus, and the judiciary strikes it down, perhaps surprisingly, because the Chief Justice was the interim Prime Minister. And there are, of course, clear separation of powers worries there. So that's the second theme, which is what is the ability, the institutional mechanism, the desire, and the capacity of judges to take on actors who might threaten or strengthen democratic stability in a particular jurisdiction. And the third idea that was arguably most prominent in Dinesha and my presentations was judicial politics within adjudication. So in approaches to interpretation, in approaches to legal doctrine, how judges, while performing their interpretive and adjudicatory function, how do they think about their place as a constitutional actor? So with those framing comments, first, while I look at the Q&A list, I should also let my colleagues on the panel know if they have any questions for other panelists to ask. And I don't know if you have the ability to post in the Q&A, but if you just let me know through our internal chat, if you have a question for other panelists, I'll also call upon you. And while I wait for them to ask their questions to other panelists, the first question that we have in the chat box is from Dr. Muhammad Habib Alam, who asks, how would you differentiate the concepts of judicial politics in good faith and judicial politics in bad faith, subject to the application of circumstantial evidence. So, and I'm assuming that the question is designed bearing sort of thinking about good faith and bad faith of the judges themselves. So that's the first question, and maybe we should take that on its own, because the second question on my list has a slightly different emphasis. So I'll invite my colleagues to indicate to me either by raise hand feature or through the internal chat if they want to take the initiative to answer this question. And while I wait for them, I will attempt an answer myself. And I think Dr. Alam, I think that it's really complicated, obviously, to go behind judicial psychology and figure out whether they're acting in good faith or bad faith, and even conceptually to distinguish between good faith and bad faith in the context of judges can be quite difficult. So there are obviously clear examples of what might be bad faith judicial action. That would be a judicial action that is motivated by self-enrichment, a bribe, or a threat, or some sort of desire for personal gain, which is clearly bad faith. But then we can move into more gray area. So a judge thinking about preserving institutional legitimacy of the judiciary while giving a judgment, and maybe not going as far as she would have liked to go against the elites because she fears the backlash which might shut down the courts. It's not clear to me that that is an example of judicial bad faith. It might be quite legitimate for the judge to hold her fire or to pull her punches and only to go so far. There's a very good book by Yvonne Tew recently published called Judicial Statecraft in the context of Malaysian and Singaporean courts, which basically talks about this very complex political negotiations that courts have to do. But I will just stop with a conceptual answer. And I think, Norman, you want to come in on this question?
Yeah, I think this, the question, the key word in the question is this good faith and bad faith. And, that relates to what, we usually explain as, we debate about impartiality. So how to see judges. Judges as a part of the state, one branch of the state. Judges as those humans who are raised in a specific socio-political and socio-economic environment. Can you really expect them to be impartial completely? Or are you talking about the relative impartiality? Now, the same logic applies to this good faith or bad faith. If you are talking about good faith or bad faith, the understanding of good faith and bad faith varies from one society to another. So one thing done in good faith could be completely, could be viewed as something done in bad faith in another jurisdiction. And if this is the case, how can you generalize that thing? And if you are talking only about Bangladesh, then I would say comparisons can be made to all those jurisdictions where there is a certain religious influence, such as Israel, such as Iran, such as the Islamic Republic of Afghanistan or Pakistan for that sake. And to some extent, in a de facto way, to India as well, not in a de jure way, because it's after all a secular India since 1950s. So my answer would be it's difficult to say. You can answer this question once you are clear about how do we see good faith and bad faith. Once we are able to lay down, clarify the parameters of good faith and bad faith, then we can answer this question if judicial politics is good for it has been done in good faith or it's in bad faith.
Thanks very much, Norman. And in fact, one clear example of bad faith adjudication is when the judge is motivated by partisan, not political, but partisan considerations, right?
Yeah.
When they are sort of paying back to their political party of choice or paying forward in the hope that the party will favor them. And that connects to a few questions that I'll combine. They mostly relate to Bangladesh, but I'll invite after it one or maybe Dinesha to comment on it from the Sri Lankan perspective as well. And these are questions concerning judicial appointments. Maybe Mohammed has something to say on this as well. Questions concerning judicial appointments and how what are the design mechanisms that can be used? I'm rephrasing three questions that are here from various people on the chat box. But what kind of design possibilities exist to reduce the partisan control that the ruling executive, be it the prime minister or the president, have on judicial appointments or judicial behavior? So obviously, post-appointment benefits in India have become a huge way of controlling judges by the executive. So I'll first invite, maybe let's start with Dinesha and then Devanu, and then if Mohammed and Norman want to come in. So Dinesha, do you want to tell us how that's done in Sri Lanka first, and the Constitutional Council?
Thanks, Tarun, for that question and the sort of the invitation to showcase what has gone on in Sri Lanka for some time. So we've had back and forth on this, what we describe as constitutional ping pong. But the idea has been to try and moderate the sole discretion given to the president under the 78th Constitution. In the 90s, this idea of a constitutional council borrowed from Nepal was proposed and first introduced to the Constitution in 2001. We, at that stage, had 7 members who were appointed and 3 coming from Parliament itself, approving the names proposed by the President, not just for the higher judiciary, but also for other public officers, and then also another arrangement for independent commissions. And the sense was that this was a way of depoliticizing judicial appointments. The government that was elected in 2010 went back on this commitment, but this Constitutional Council was brought back in 2015 in a slightly different form. Now, I know Tarun calls this a post-political approach, post-partisan approach, right? Where you give the opposition as well a stake in the game, and you have cross-party consensus which approves or disapproves the proposals made by the president. Many of you on this call would know that Sri Lanka had a constitutional crisis in 2018. And eventually the judiciary was called upon to decide whether the dissolution of parliament by the then president was within the constitution or not. And the Supreme Court declared that it was unconstitutional. And the consensus at that time was that the judiciary was able to rule impartially because it was independent, and that was because of the Constitutional Council. Now, of course, since 2020, we no longer have a Constitutional Council. So the lesson learned in Sri Lanka seems to be that when political parties are weak and they need to form a coalition, they are willing to enact amendments or reform which reintroduces the Constitutional Council. When a political party has the 2/3, it would like to do away with the Constitutional Council, which clearly reflect some of the dynamics that we've discussed about threats from without to judicial independence. I'll leave it at that.
Thank you very much, Dinesha. That's really helpful. And anybody who's interested may also want to look at Nepal, which sort of came up first with this idea of Constitutional Council appointments, including both the opposition and the government, and giving an equal say. So, Ridwanu.
Thank you, Tarun. Actually, you have merged 2 questions of similar nature. So, the first question is how can the Prime Minister's influence can be minimized, or how can the judicial system overcome the bad influence of governing political party. Yeah, and so with reference to Bangladesh, we often say that the constitution, in terms of separation of powers, is overbalanced. So the prime minister has all power, something like this, in terms of judicial appointments or judicial removal. But that doesn't tell you the whole truth, because the Bangladesh constitution enacted judicial independence as a basic or core feature of the constitution, one of the basic structures of the constitution. On the other hand, if you read down the lines of the provisions relating to judicial appointments, you'll see that the constitution first gives you a broad template of qualifications, then say that further qualifications need to be determined by law. So once you take judicial independence as a basic feature, the prime minister is ipso facto disabled to exert her overall influence on the judicial appointments. So it's a matter of political willingness in Bangladesh. So that's the status of constitutionalism that develops. The insider reader would be able to remind that during 2007 and 8, when Bangladesh didn't have a political government in power, rather it was a caretaker government backed by military establishment, there was an ordinance passed by the president, promulgated by the president, regarding the judicial appointment, and it proposed a forum for the appointment of judiciary, and it was challenged before the court. And the court said that, yes, this is fine, fantastic idea, but the forum should be consistent in a way that the judiciary has a wider say than other two parts or organ of the state. If you compare these to the Pakistan situation and Nepal and Sri Lanka, in Pakistan, you had a constitutional council or something like this to appoint judges, and it was challenged, and the court exactly said that no, the composition has to be in a way that the judiciary has a greater say than the other two organs of the state. So the one way to minimize the prime minister's influence in terms of Bangladesh is to have a sort of constitutional dialogic pattern of appointment process in which the three branches of the state shall have a say in terms of the appointment of the judiciary. We have to do this anyway. So that's my brief response to it.
Thanks very much, Ridwan. Mohammed, did you want to come in on this question and talk about the appointments process in Afghanistan?
Yes, sure. As I stated before about the appointment of judges in Afghanistan is absolutely based on the Afghanistan constitution. As I stated that the Supreme Court is a high authority, the judicial power, and it has 9 members. These 9 members must be appointed by the president and should be introduced to the parliament. Then the parliament are going to vote for them in order to be the members of the Supreme Court, and they might have a particular limitation of time to work there. Then the head of the Supreme Court might introduce other judges to the president. Then the president might endorse the proposal, and then they might have the authority to perform judicial affairs. So I think that generally in Afghanistan we have a kind of mechanism that not only the parliament but also the executive power along with the Supreme Court are involved in this in the appointment of the judges and the members of the Supreme Court. So that's a good mechanism, I think, because we can't see role of parties in election of the judges and something like that. So it means that we can't see much obstacles and much interference of the parties in the election and appointment of the judges.
That's very interesting. Thank you. And I think this idea of including the opposition in appointments also becomes probably more complicated in a particularly fraught transition regime like Afghanistan. But I guess that's a question that you have to face further down the line. We're coming to the close of the session. I think I have time only for one more question. So I'm sorry, panelists, we don't have time to take your questions. I'll just take the top question from an anonymous attendee who has asked Norman how judicial populism has impacted the quality of democracy in Pakistan. Norman, if you can try to answer that relatively quickly. It's a big question, I know.
Yeah.
That'll be useful.
Yeah, I think this is the usual question, and this question is, is not only important for the authoritarian and hybrid regimes, but it's always the center of discussion in the developed democracies. That if the question regarding the majoritarian and the counter-majoritarian difficulty, but it undermined democracy, but it undermined democracy in a way that the elected representativeness of the democracy has been undermined. But on the other side, the accountability part of the democracy has been strengthened. So, and it takes us back to the question, how do we see democracy? Are we looking at the representative model of democracy, or we are looking at constitutional model of democracy? If we are looking at representative model of democracy, and our reference point is the parliamentary sovereignty and the parliamentary democracy borrowed from the UK jurisdiction. By the way, many people here are crying about the accountability of political elites, vertical and horizontal accountability. So we need to look, we need to see how we are looking at the model of democracy. If our reference point is constitutional democracy, judicial populism strengthened constitutional democracy. If our reference point is representative model of democracy, of course, judicial populism undermined elected feature of democracy, because 2 prime ministers have been disqualified. And, we don't know if the 3rd prime minister is going to be disqualified or not. Only, future can tell, the future developments can tell us. So, so my answer is, depending upon the model of democracy, you can, you'll be in the best position to say if it undermined or strengthened democracy.
Thank you. That's a very nuanced answer. And I think that brings us to the close of today's very interesting panel. In my thanks once again to all of
Tarun, you may like to take Gaurav Mukherjee's question, if you like, very quickly. Did you see that? I just intervened because I thought that you didn't see that.
I've seen it. I just think that, given that we are over time, I will speak to Gaurav.
It's okay. It's fine. Yeah.
I will speak to Gaurav about it separately. It's just that, it's a fascinating question. I would love to answer it, but I didn't want to. Also, as chair, if there's an embarrassment in prioritizing a question that gives you more airtime, right? And as we know, with these South Asian conversations, India is often a local imperial power. So I think less airtime to me and less airtime to India are both of my priorities. So Gaurav will take it outside. But with actually that's a helpful way to close it. And I love the inverted map of South Asia on Dinesh's wall. Right, we need to look at South Asia from multiple perspectives, and not just what we are used to. Sri Lanka can be at the top of the region once in a while, and next time hopefully we will have Nepal and Bangladesh and Bhutan and Maldives and Myanmar joining in the conversation. So thank you all for attending. A huge thanks to Norman for organizing this, and those of you who don't know the Junior Faculty Forum for South Asian Law Teachers, please join us. We discuss workshop paper every month, and more details are available on Twitter. for the JFF events. So thank you all very much, and see you whenever we meet next time. Bye-bye.
Thank you.
Thank you.
Thank you all.
Thank you.
Thank you.